You're charged with the offense of online solicitation of a minor, sexual conduct as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. 2024 CR 012225, State versus Michael Gonzalez. Can I have parties announced?
Stephen Spear for the state.
Martin Getto, attorney for Michael Gonzalez.
And are you Michael Gonzalez?
Yes, ma'am.
And defense, I believe there's something you wanted to place on the record.
Yes, if I may, Your Honor. Mr. Gonzalez, we've gone over the list of evidence that's been turned over to us by the district attorney's office, correct?
Yes.
And you are aware that there was some data from a phone extraction which was just obtained by the DA's office yesterday, as a matter of fact, correct?
Yes, sir.
Now, I also inform you that we haven't had a chance to review that personally, is that correct?
Yes, sir.
However, we did go over the written reports.
Yes, sir.
Now, knowing that we haven't had the chance to review that phone extraction, is it your desire to still go forward today and enter a plea?
Yes, sir.
Has anybody pressured you, coerced you, or into that, making that decision?
No, sir.
That's all.
All right. So other than that, defense, have you received all discovery?
Yes, Your Honor. Well, I believe there was one item which was an Axion report, which wasn't.
It is documented in the discovery receipt. I just did not attach it to the stipulated evidence. It is an Axion list just saying which videos and what reports are contained therein within Veripic.
All right. And Mr. Gonzalez, did you review the true bill of indictment with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I am, Your Honor.
Mr. Gonzalez, did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
All right. You're charged with the offense of online solicitation of a minor, sexual conduct as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There are no applications, and there's to be Chapter 62 compliance. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead?
Guilty.
State, any evidence?
Yes, Your Honor. State would offer State's Exhibit Number 1 and its attachments.
No objection.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Right from the start, the stakes are crystal clear. A second-degree felony ISNT minor trouble. It carries the possibility of decades behind bars. Online solicitation cases often begin with undercover sting operations where officers pose as minors to catch predators before an actual child gets hurt. But here's the big question: did the defendant truly understand the consequences of what he was doing when those messages were sent?
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right, so why are you doing this?
Stupid.
Well, I mean, no, because here's the thing. You clearly know that this is someone who's underage. And of course, it's a sting operation. But you knew that person, or you thought that person was underage.
It was a dumb choice.
Well, I don't know if it's a dumb choice. I'm trying to figure out if this is something he enjoys, the underage aspect of it, or if there's something else. Because I'm trying to figure out whether I should accept this plea and whether or not he's a danger to other people. Because dumb choices, I don't think it's a choice. Is it a dumb choice? Yes, but I don't think that's the reason he made the choice. Because how old is he?
At the time, Your Honor, he was 31.
All right, you're 31 and trying to have an interaction with a 15-year-old. Why?
I have no excuse for it.
Anything to say, counsel?
Well, Your Honor, he's been in custody for an extended period of time. He doesn't have a criminal history. Pretty much from the beginning of my representation in October of last year, he has mentioned that he's wanted to accept responsibility for this. There's nothing from his past which would indicate any continuing danger. In the stipulations, and again, this doesn't excuse anything, but in the stipulations, he basically just says he hasn't had I believe he hasn't had a girlfriend or been around, hasn't had a relationship in 4 years. He's always told me it was just a terrible decision on his part. But he's also assured me that once that happened, that was it. It was a shock to his system, clearly, and it's obvious it was shocking to him in the video from the body camera footage. It's one of those things where he hadn't had the opportunity really to think at that moment about some of the ramifications of what was going on. But he has these 225 days that he's been in custody. He knows also, he's been advised about the Chapter 62 compliance. And he knows that it's because of this inexcusable decision on his part that he's got a lifetime of consequences.
All right, anything from the state?
Your Honor, I'll just confirm what defense said in terms of the very minimal criminal history from Mr. Gonzalez. There were a couple Class B marijuana charges. He had a couple misdemeanors as a juvenile, but no felony arrest for Mr. Gonzalez prior to this incident.
And one last thing, just he was grateful that there wasn't an actual person involved. It was just an adult posing.
This moment is more important than it looks. The defense admits there's new phone extraction evidence they haven't fully reviewed yet, and that can be risky. Phone extractions in cases like this often contain the full message stamp sound, sometimes deleted conversations. Choosing to move forward without fully reviewing it means the defense is confident the plea deal is still the safest path.
There wasn't an actual individual that was harmed by this.
All right, this is what the court is going to do. The court is going to follow your agreement, find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's to be Chapter 62 registration. There's to be no contact with minors and no residence with minors. Is there anything else with regards to sentencing?
No.
Nothing from the state.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Right, because this is a plea bargain agreement, because I followed the plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You do understand?
Yes.
All right, we can go off the record. Here's the thing. Sometimes the people on the other end, they are underage people, right? And I can tell you, some parents are not good parents, but then you have some parents who are trying to do the best they can, but they really can't keep up with technology and what their children are doing or should not be doing. So you need to always be thinking about that, and you should be trying to make society better, not go through loopholes. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Mayor.
You're welcome.
Thank you.
Court is calling 2025 CR 004894 State versus Jack Daniel Cross. Could I have parties announced?
Andrew Harrison with State.
Alfonso Otero on behalf of Mr. Cross. Good morning, Judge.
Good morning. And is there going to be any applications?
Yes, Judge.
Yes.
All right, are you, probation, this is an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Cross, did you review the document entitled Application for Deferred Adjudication?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? Counsel, do you waive the reading of the indictment?
Good day, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? All right, you're gonna have to speak up.
Yes, ma'am.
Did you understand you're charged with obstruction or retaliation as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to enter into a plea in this case and give up those rights?
I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Good day, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Cross, has anyone
Now we're entering the plea stage, and this is a huge turning point in any criminal case. By pleading guilty, the defendant is giving up several constitutional rights, including the right to a jury trial and the chance to confront witnesses. Courts go through this long checklist to make absolutely sure the defendant understands what has giving up. If that process isn't clear, the plea could later be challenged.
threaten you, coerced you, or placed you in fear to get you to enter the plea?
Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea bargain agreement, the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence?
It offers Exhibit 1 and attachments.
No objection, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there's sufficient evidence to find the defendant guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge. Just pull the plea bargain.
All right. So, Mr. Cross, I see that you were taken to the hospital. Have you received a diagnosis or no?
Yeah, for schizophrenia.
All right. So, are you currently on your medications at the jail?
Yes, ma'am.
All right. And there's no issue, you believe, with competency or sanity at the time of the offense?
No, Judge.
All right. If you're released, do you have a place to stay?
Yes, ma'am.
Would you be staying with someone?
Yeah, my mother.
Okay. And are there any minors in the home, any children?
Oh, no.
All right. So what do you spend your time doing?
I try to occupy my time with like playing video games.
Okay. Have you ever been employed or did you receive SSI?
So I'm currently unemployed.
All right. When's the last time you had employment?
So I try to work at various different jobs doing like tedious things.
Okay. Did you finish school?
Don't know.
How far did you go in school?
I made it to ninth grade.
And why did you drop out?
I just was had a lot of stress going to school, so I decided to not further my education.
All right. Do you have any children?
No, I don't.
All right. So this is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication.
And there it is, the single word that ends most criminal trials before they ever begin. Guilty. Once that plea is entered, the focus shifts from proving the crime to deciding punishment. But something unusual is about to happen. Instead of simply accepting the deal and moving on, the judge is about to dig deeper into the why behind the crime.
Does your client have any criminal history?
Other than the word judge.
So I did receive a failure, it's going to be silent or abusive phone call to emergency services in Midland County. I forgot what county it was.
All right. So this is what I'll do. Instead of the 4 years deferred adjudication, I'm going to do 5 years deferred adjudication. But if he completes everything successfully, he can come back and ask for early termination. So 5 years deferred adjudication. Probation, how long is the MIC evaluation in custody?
Judge, at least 2. And then depending on that, he needs to follow consent for hours.
I mean, and I'm going to tell you, here's my fear. You obviously need to be on medications. During this episode, it's clear to the court that he wasn't on medications. So I can do one or two things. One, I can have him remain in custody and wait for the MIC evaluation. Is the time the same in and out of custody or no? Okay. How much longer out of custody? Sure. Okay. Please. Yes. June 9th. All right. So what we'll do is I'll do sentencing on June 9th, but they may be able to have it done before then, okay? Here's the reason why I'm doing this. Based upon what I'm reading in the police report, I don't want to set him up for failure. I want to make sure that he has a case manager, that he has his medications to take. Otherwise, that's not going to happen. And you're going to end up right back here. And because this is a deferred adjudication, you're looking at potentially 10 years in prison, and I don't want that to happen, okay? So I'm going to set it for June 9th, but they'll probably have it done before June 9th. And then as soon as it's done, we will take it up. Definitely at the latest June 9th, but it'll be before then.
Your Honor, I had a question.
Sure.
Would you take into consideration my back time? Because I've already been in custody for almost 90 days, more than like 100.
All right, that's something that's completely separate from this plea.
Oh, okay.
Usually taking in consideration time has more to do when someone decides they want to do a prison sentence.
Okay.
So we're going to try to get it done as quickly as possible. I'm sorry we can't get it done any sooner. This is done through third parties. It's not done through me, okay? So at the latest, June 9th, at the latest. But the probation officer has your attorney's contact information. So if we have it before then, we'll bring you in before then. And defense, if for some reason you're out of county, you can always Zoom in and we'll get it done that way.
Thank you.
All right, thank you.
Thanks, Judge.
You're welcome.